Okay, so again, I'm, as I told you yesterday, I'm an economist, so I'm going to focus less on the legal issues and more on trying to get my slides to work. Thank you. So same discussion, third-party litigation. The amount of financing by third parties, hedge funds, and other kinds of investors in lawsuits as an investment vehicle is increasing. The legal status, as Steve said, is still being debated, and fortunately, I don't have to think about that, not being a lawyer. But I have read some of the cases, but it's hard to tell exactly what's going on. But it is increasing. The effect is to reduce the costs of litigation, and if we reduce the cost of litigation, and economists can tell you there'll be more of it. The law of demand says if something becomes cheaper, then we get more. There's actually some evidence from Australia where they do have increased third-party financing, that some empirical evidence that the effect has been more lawsuits being filed. There's an increase in lawsuits financed by third-party litigation. So the question is this good or bad? And in my remarks, I'm going to concentrate. There's lots of different kinds of cases that are financed. Some of them are small consumer-type cases where someone is injured, they lose wages, they can sometimes borrow the money from a third party and then pay them back if they win the lawsuit. These are sometimes contested as usury cases, and there's a whole law on that. But I'm not going to focus on those kinds of cases. I don't have any real problem with those. I'm going to focus on larger cases, class action or group action type cases where there's more involved, and those are the ones I'm going to look at. The first thing we can say, pretty much unambiguously, is that if we allow more financing, it's good for parties who are within a lawsuit. If you're already in a lawsuit and you can get financing for that lawsuit, you benefit. I mean, economists believe deep in our hearts that when you have more, that when people engage in voluntary transactions, they benefit. So if we allow lending to consumers or to people in a lawsuit, then those people benefit. The lenders benefit because they're making an investment that they think will pay a positive return. The borrowers benefit because they're engaging in a voluntary transaction. So for the people who are in a lawsuit already, and that's what some of the other panelists will talk about, for those people, there's no doubt or little doubt that allowing third-party financing is a benefit. But there are two other questions. Is it good for society? Is it good overall to allow this? It's a change in the legal rules, the way we do business, and it's a fair question, a public policy type question or an economics question, which to me are the same thing. Is this good for society to allow this kind of lawsuit? Well, what are the benefits? If there are benefits from lawsuits, from this type of lawsuit, or any lawsuit really, the benefits are from deterring harmful behavior. The whole benefit of the legal system, the whole purpose of the legal system is to deter harmful behavior, to get people to internalize the costs of their harmful actions and to make people do good things. In particular, for the type of cases I'm talking about, the particular benefits are from cases where there are low individual costs but high group costs. If a million people each lose $10 from some action that could be prevented at a cost of $5, then clearly that action should be prevented because there's a social gain of $5 million from preventing it. Just as clearly, no one will bring a lawsuit for $10, and so that type of harm can go on. And that's what we're concerned with, is those small, individual, large group cases, sufficiently large given the cost of lawsuits today. You can increase these numbers by a big amount, and it still wouldn't pay for an individual to bring a lawsuit. But the U.S., we already do a lot about that kind of case. We have lots and lots of class actions, and I've looked a little bit comparison of the U.S. with some other countries, and we are very favorable towards this type of group or class lawsuit. I originally called these class actions, but I was corrected by a colleague who said these are more general group-type lawsuits. They aren't all legally class actions. Each party pays its own legal fees in the U.S. So there's no loser pays rule. That means that someone is less deterred or not deterred from bringing risky suits, because the risk, especially if it's a contingent fee case, for example, the risk is the lawyer's time, but the risk in England, for example, where you have to pay your opponent's fees, if you lose, the risk is much greater. So the loser pays rule favors litigation in the U.S. Contingent fees favor litigation in the U.S. You can get a plaintiff, doesn't have to put anything up to finance the lawsuit, and so again, contingent fees favor lawsuits. There's some evidence that plaintiffs' law firms are growing in size and power. They're more able to finance no longer the single practitioner. Plaintiffs' law firms are bigger, wealthier, and able to finance more types of litigation. The U.S. has opt-out class litigation. Yesterday in the privacy system section, we talked about opt-in and opt-out. This is another opt-in or opt-out. But in the U.S. for class litigation, it's an opt-out system. So as well as being judges, you're people, and you always get in the mail letters from various law firms and others saying, we're bringing a class suit. You may be a member of this class. Do you want to opt out? And if you don't opt out, then you're a member of the class. In England, for example, it's an opt-in system, meaning that a plaintiff's lawyer has to actually find the members of the class and get them to sign on, a much more difficult task and one that greatly discourages class-type litigation. So the U.S., as I say, the question of this third-party financing is, do we want to increase the scope of this type of litigation? But we already have lots and lots of rules that are friendly to group-type litigation. The question is, do we want to increase it even more? But there is some evidence, substantial evidence really, that the U.S. already spends more than other developed countries, other OECD countries, for example, much more as a percentage of GDP on the legal system than do any other countries. So we already have lots of rules in place that make group litigation easy. We already spend more than anybody else. The question is, do we want to increase that in addition? What are the costs? I said the benefits are discouraging harmful behavior. The costs, as I say, one cost is more lawsuits, and a lawsuit is an interesting thing. A lawsuit, we talk about externalizing costs or internalizing costs, but a lawsuit has, by its very nature, a very large component of external costs. Part of the external costs are you guys, right? If A sues B, then society provides the judges and the court system. That's a cost that A doesn't have to consider when he decides whether to sue B because it's paid for by the state. So the plaintiff doesn't consider that particular cost. But more important, when someone is sued, a cost is imposed on the defendant. The defendant must then hire his own lawyers and fund his own defense. The plaintiff, in calculating should I bring a lawsuit or not, calculates his own costs and benefits. He doesn't calculate the external component of costs, the social component, and the cost that he imposes on the person that he is suing. So that's one external cost from lawsuits. The costs of both sides then, once the lawsuit's filed, both sides have costs of lawyers, experts, and so forth, but the defendants, at least in the type cases I'm talking about, defendants will generally have larger costs than plaintiffs. Defendants will have very high or sometimes very high discovery costs, electronic discovery, time of executives, and so forth. So all of these costs are imposed upon defendants by plaintiffs when they choose to file a lawsuit. It doesn't say anything about whether a lawsuit should be filed or not, but it does say that here's a cost of lawsuits that should be considered, and that cost would presumably increase if we allow more third-party financing, which would lead to more lawsuits. I think there's a second type of cost, a long-run cost, to allowing this that we should think about. If we allow third-party financing, what we're doing is creating a set of actors with an interest in more litigation, a set of financiers, people who specialize in financing lawsuits, whether they be hedge funds or other kinds of enterprises, but people with an incentive in making money from litigation, and I think this would then create an incentive to try to move the law towards a direction of more litigation. I think the trial lawyers have already done this over time. They've changed the law in various ways by litigation and litigation strategies, making litigation more likely. We saw yesterday in Henry Butler's presentation that state third-party or state little FTC Act cases have been increasing. Part of the reason, I suspect, although I haven't looked into it, is that there have been lawsuits aimed at changing rules in states, changing rules in various ways so as to make lawsuits more likely. I have written about the tort lawyers doing this in the context of tort law through sequencing of cases and bringing of particular cases. And I think if we had third-party financing, we could expect more of that. We're now creating a party, and presumably these would be large investors with very diversified portfolios of legal cases, and they would have an incentive to move the law in the direction of more litigation. Now, if we think, as Steve said, if we think there's lots of individual rights that are not being well represented, then moving the law in that direction would not be a bad thing. If we think that we already are pretty far along that line, then moving the law in that direction might not be such a useful thing. Bottom line, for an individual in a lawsuit, being able to get outside financing, or for an investor, being able to provide outside financing is a good thing, but my own guess is that the long-term cost to the legal system of allowing this would, increasing the amount, would do more harm than good, or in other words, that our predecessors who worried about champerty and maintenance probably had it right, and we should perhaps worry more about that as well. Thank you.